Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We have 3 sets of arguments this morning. First is 2811, Hartzell versus S.O. from Travis County and the 3rd Court of Appeals District, consolidated for argument with 2812, Trauth versus K.E., also from the 3rd Court of Appeals District and Hayes County. And we have allotted 20 minutes per side in those cases. Then second is 2128, Total Energies, E&P versus MP Gulf of Mexico from Harris County and the 12th Court of Appeals District. 20 minutes for each side in that case. Justices Huddle and Young are not participating. And then finally, 21291, Texas Medicine Resources versus Molina Healthcare of Texas from Dallas County and the 5th Court of Appeals District, consolidated for oral argument with 22138, United Healthcare Insurance versus ACS Primary Care Physicians Southwest, a certified question from the U.S. Court of Appeals for the 5th District, and the court has allotted 30 minutes for each side in those consolidated cases. The arguments this morning are being live cast and will be available later on the court's website. We will conclude the arguments this morning before breaking for lunch. We're ready to hear argument in the first set of cases.
May it please the court. Mr. Davis will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. The overlapping issue in these 2 cases is whether state university officials act ultra vires when they revoke a former student's degree based on academic misconduct that occurred while the student was enrolled at the university. That issue is jurisdictional, and a decision in the university's favor on that issue would dispose of both cases. So I'll focus my time, if I could, on that question of degree revocation authority as to both the University of Texas and Texas State. Now, both of those institutions—
Do you want to talk about ripeness at all, or are you—
I'm happy to, Your Honor, but as I said, because all of these issues are jurisdictional, the court can choose which one to address first. And in our view, the ultra vires question goes—
I just have one question about the ripeness issue, which to me does seem kind of preliminary. And that is, in one of these cases, the argument is it's not right because you haven't, your client hasn't, UT hasn't taken away the degree yet. But I think in the second case, the argument is they can't recover because they're seeking retroactive relief because we already took away the degree. And it seems to me that's a catch-22 for the plaintiffs here. They can't prevail either way.
Well, in our view, it's just a natural extension of this court's precedent on both of those issues. But I think we see in the SO case a way that the parties have ensured that the court would have jurisdiction over a due process claim by allowing an abatement that would provide an opportunity to take that case to court if it comes to pass that the degree is revoked in the SO case. So by that time, the claim would be ripe, but there would be a window for the court to exercise jurisdiction on a due process theory.
Before UT actually takes action, takes the vote or whatever to revoke the degree.
Implements that so that after that there would be a retrospective relief under Heinrich, right? But before then, there would be a window where the trial court would have jurisdiction. And I think that's what the abatement agreement tried to preserve. Okay. But if I could start by talking about the rules that are in place at both of these institutions. those rules expressly allow the universities to revoke degrees of former students, again, based on academic misconduct at the time they were students. At the University of Texas, that's Rule 11-501 and 502N from the rules that SO contends apply here. And at Texas State, it's Rule 2.32.
Are you
Now,
making a distinction between former and current students here in your argument now?
Well, all of the conduct we're talking about occurred when the students were enrolled, right? And so my friends on the other side have tried to say, well, here there is a distinction. Of course, we're not talking about rules governing current students, but we are in the sense that we're not saying that these
That's when it was
universities—
earned. That's what you're talking about.
That's right. The universities, if they had discovered the misconduct before the degree was awarded, would never have awarded the degree in the first instance. All we're saying is if they discover it later, they can exercise that same discretion not to award the degree or at that point revoke the degree.
And do you agree that they could not, I'm not saying what the rules say right now, but they could not revoke a degree based on anything that happened after the graduation?
I think it would be a much harder argument to make.
But you're not willing to say that they couldn't do it?
That's right. I think I would need to know the facts of that scenario.
And you say about academic misconduct. What about if it comes to light later that someone engaged in personal misconduct during that time? Would that also be something they could revoke a degree based on?
I think that would also be a harder case, Your Honor. But when the university can say that if they had known about the academic misconduct, that would have been a reason not to award the degree, then they can revoke the degree on that basis. And that's as far as we're making the argument today, because that's all we need.
And does it ever end? Could you revoke the degree from someone who is dead?
I think that there is no formal time limit. I think there could be a practical time limit in the sense that the university would need to substantiate its case. But yes, even in that scenario, I think the university would have that power under its rules, and the question would be whether it would choose to pursue that.
So
Now-
so I'm a little confused. I thought that your argument was really based upon this idea that the decree had not been earned, basically, to get to the bottom of it. And if you're saying that it could be based, or you're not willing to let go of the argument that perhaps in some situation it could be based upon behavior that occurred after the degree was awarded as opposed to earned, can you give me a hypothetical of what that would be?
Well, there are some disciplinary proceedings, misconduct that doesn't have to do with academics. So sexual assault, for instance, that
So
could—
if there was sexual assault, you'll say totally unrelated to the decree being awarded, and for which there's other punishments that are available, obviously, you're saying that perhaps a university could revoke a decree based upon that?
I think that would just be a different analysis, and I'm not taking a position on that today. What I'm saying is when there was academic misconduct that would have prevented the award of the degree in the first instance, the university can revoke on that basis. Now, the rules I mentioned, of course, have to be authorized by statute, and that's an important point that I want to address and point the court to the specific statutes that give universities in particular broad rulemaking power. So just to start with the general standard, and we see this articulated in Pruitt, among other cases from this court, an agency has rulemaking authority consistent with the express authority stated in the statute or implied authority, but even that test is pretty forgiving because the rule needs only to be in harmony with the general objectives of the statute or the act. But here, the legislature has given universities an even freer hand, and we see that in the Education Code, section 65.31C and 95.21B, where the legislature says, with respect to the University of Texas and Texas State, that they can promulgate any rules that the board deems either necessary or desirable. And so the legislature is taking this a step beyond the necessity analysis that we see in cases like Pruitt and saying the universities can do whatever they see fit in the academic context.
It seems that a question that we need to think about is, what is a degree? What is the nature of this thing that we're arguing over. Is a degree, I mean, I think you concede that a degree is the property of the degree holder, at least for purposes of invoking some due process protections, and you would, I'm sure, debate what process is due, but it is property in that regard. Normally, if I grant someone property in exchange for, something like tuition or their work or whatever, I don't get to revoke somebody else's property, right? I have to go to court under a theory, rescission or some other theory under which I could, take back this property that's been conferred upon somebody else. So if that's not what a degree is, I assume your position is that a degree is not like that kind of property. What is it? And does it entail some ongoing affiliation or relationship between the university and the degree holder? And if so, I wonder if everybody who holds a degree might sort of need to reconceptualize what it is that they have. I think we really need to answer what a degree is, and that's not really addressed in the briefing at all.
And Your Honor, we're not disputing that there's a property right in a degree, and I think at a minimum, a degree is a certification by a university that a student properly completed what needed to be completed to earn that academic credential and get that diploma. And that's why the revocation power...
Is it a record of that decision having been made in the past, or is it sort of an ongoing, vouching almost for the person?
I think it could be conceptualized both ways, but in the narrowest sense, it's a certification that the standards were met. And that's why a university can come back and say, well, actually, we've discovered evidence that those standards were not met. And we've cited cases from other jurisdictions that have talked about degrees and what they are and what universities' powers are in this area. And those other cases deal with broad statutory grants, just like the kind we see here.
If I give my law clerks something at the end of their term, a golden plaque they're going to hang on the wall that's worth a great deal of money and is going to lend prestige to them. Let's just imagine that a clerkship with me lends prestige. But if I grant that to them in exchange for their work, and then I find out later that every memo they wrote me was fraudulent and they weren't even who they said they were, I don't get to go in their office at a law firm and pull that off the wall and say that's mine now. I've got to go to court, and I've got to do it within the statute of limitations, and I've got to get that back through a legal process, not through my own determination that I shouldn't have granted it in the first place.
That might be correct, Your Honor, but the legislature has created a special system for universities that gives the universities quite a broad range of powers that are not necessarily expressly stated. And we see that, for instance, in statutes that don't expressly give some universities, such as A&M, Texas Tech, Texas Southern.
Let me ask you this, and it's true, the legislature has given universities broad authority to protect the integrity of these degrees, is what it amounts to. But can't that be protected through the court system?
I suppose it might be, Your Honor, but of course what we're talking about today is this question of whether a university can do it internally, which is often in everybody's interest. And if the court were to hold that Texas universities can't do that, it would be putting those universities at a disadvantage compared to peer universities throughout the country. We've cited a number of states that have said their universities do have this revocation power, even absent an express grant of authority. And we see the legislature in 51.352 of the Education Code and 354 of the Education Code saying we want Texas universities to strive for intellectual excellence and be on par with their peer universities throughout the country. And
when you say that it might be in everybody's interest, there are complaints interwoven with this about the procedural due process or lack thereof that was afforded initially by the university. No discovery, no right to counsel, no right to cross-examination, One of the complainants sat on the board of professors who initially voted to revoke. And it sounds to me like, from the briefing, that the university is backing away from that first set of process and is perhaps suggesting that there would be more process. But, who makes the rules then? And if we agree with you that there is some limited power that the university has, is there any complaint left about procedural due process?
So a couple of points. One is in this court's decision in University of Texas Medical Center versus Than, the court explained that in the university setting, the due process apparatus that you would find in the courtroom is not the same at the university, and that's permissible. The second point is that students who go through that process do have the ability to go to court and say there was a due process violation and ask for prospective injunctive relief in the form of the process that was due. And so there is a check by the judiciary on this process. And if I could just point...
You asked for rendition, but would you say that there should be
sure.
a remand and, for consideration of the complaints about the process? And given that apparently there's going to be some new process if the university has the power.
Right, so we have two different procedural postures here. In the SO case, I think we're at the end of the line because SO had a bunch of declarations that she sought relief on, lost in the trial court, cross-appealed as to some, but didn't petition for review. So that's it until there is a hearing and she could potentially raise a new due process claim then. For KE, the request for related to the due process claims were all phrased in the past tense, that there was a due process problem in the past. To the extent the court would read that as allowing for prospective injunctive relief, that could potentially be still live. If I could just make one more point in my remaining opening time, it's based on sections 65.31b and 95.24. These are express legislative grants of authority to award a degree. And we see in the context of the Education Code a number of instances of the legislature granting the initial action but not the flip side of the coin, to erect a building but not demolish it, to admit students but not expel them, to deposit money in a bank but not withdraw it, to appoint a chancellor or a president but not dismiss them for misconduct. We have the same situation here with awarding and revoking. They're two sides of the same coin.
And all of those things that you just mentioned are clearly within the jurisdiction of the university. And the question here, I go back to what is a degree? Is my degree hanging on my wall in my office still, do I hold it at the sufferance of the University of Texas, or is it mine? And if we don't have a clear analogy in these other examples.
And as I said earlier, if the university didn't like you holding that degree because of something that happened after your graduation, I think that would be a very different case. If the university found out that somebody cheated on all the exams he or she took to get that degree, that's what we're saying, that if there were evidence of that, the university could say, well, that degree was never earned in the first place.
But then we still get back to the due process
And then the due process question, sure.
And I'm unclear about what you're saying. Surely there has to be some process.
Yes, the university has its own process. And if a student goes through that process and at the end of it, the degree is revoked and the student says, well, what they call due process isn't due process, that student can go to court and get a court to review whether that due process was sufficient.
So is that a suit for judicial review under the APA?
It would not be, Your Honor, because this is not governed by the APA. The legislature could grant a right to judicial review in this context, but hasn't. I think it would have to be in the form of an ultra vires claim or a claim under City of Beaumont versus Bullion, based on the idea that under Article 1, Section 29 of the Texas Constitution, the previous action was void, which is how you could, I think, get around any retroactivity problem in that instance.
Universities or institutions of higher education are not considered state or defined as state agencies for purpose of the APA.
That's correct.
But you don't disagree that they are nonetheless state agencies.
Correct.
And so what does that mean for something to be a state agency but not be subject to the APA? Is that give them more or less authority? Is that the common law of administrative regulation at that point, or is it really just constitutional review like you were describing a moment ago?
Well, I'm trying to think for purposes of this case, I don't know that it matters other than to say there's not a right to judicial review that could go through the APA. The students couldn't bring a 2001.038 challenge to the rules, but there would still be mechanisms to bring a constitutional due process claim or any other constitutional claim arising from the process at the university.
Is it a constitutional claim for an agency that is not an APA agency? Is it a constitutional claim that it has exceeded its authority that the legislature has granted, since agencies cannot do that?
I think that would be properly characterized under Patel as an ultra vires claim based on the exceeding the powers granted by statute. See, I'm over time.
Any other questions? Thank you, Mr. Davis. We'll hear from the respondents.
May it please the court, Mr. Field and Ms. Kawaja will present argument for the respondents. Mr. Field will open the first 10 minutes.
May it please the court, good morning. I want to correct two fallacies I see in the state's argument right away. First is the issue you've highlighted already in your questions, the difference between a former student and a current student. A graduate of a public university has a protected property right in their degree. They're not subject to the university's discipline any longer, and that property right cannot be taken without due process, which we believe includes judicial review. Secondly, this is not a case that can be cabined to academic dishonesty. You've hit it on it already in your questions. Texas state's own rules have multiple grounds for revocation of a graduate's degree. The one at issue in this case is academic dishonesty, but I'm going to talk about some others that are a bit more, I hate to say it, but they're a bit more nefarious in today's world.
Before you turn to that, can I talk on your first point? Are you saying that if upon graduation the student has the diploma in hand, whatever the moment in which it's an actual completed act, and then says, you know, that doctoral dissertation that I had to go to, it's an absolute requirement for getting a PhD. I had one of those Mission Impossible kind of masks, and I actually hired a PhD from, you know, Harvard or something like that to sit there and pretend to be me. Ha ha ha, nothing that can be done about it. What do you say would happen in that instance? They can't revoke it through their own power. They would have to go bring a contract claim, a fraud claim?
Or a fraud claim. And there's no limitations, of course, for the state of Texas. You asked earlier if they could do it to a dead person. Yes, they can. In that situation, someone has committed fraud, outright fraud. They pull off the Tom Cruise mask. They're suddenly, you know, someone smarter than the current student, and they got the degree through false pretenses. I mean, it seems like a pretty easy fraud claim. But instead, what's happening is, for example, Texas State, they form their own investigatory committee. They even pull professors, in our case, from other universities, don't know why. And then they have that same investigatory committee decide whether that degree should be revoked. It goes up to the president of the university, who the standard of review for that, according to her, was there's no manifest injustice here. Again, don't know what that means. It then goes to the Board of Regents, and you never see a court of law.
So, Mr. Field, so are you saying in the scenario that Justice Young brought up where the person is actually pretending to be somebody else, and it's clear that they did not do any of this work themselves, that in that situation the university could revoke the decree? I'm
saying a university can always seek to revoke a degree. The key, to me, the key phrase in this situation is, can a university revoke a degree in and of itself through its own disciplinary proceedings? Can they hail?
Well, could they in that situation?
No.
So you are saying even if it turns out that, you know, I had Justice Huddle stand in for me and get my dissertation, my master's from Duke, and it was really her.
I'm saying that that's a very clear example of somewhere where they're going to get their degree revoked. The question is, what's the process? And this court's never really taken up this issue of what does this property...
Well, what if that very student re-enrolled, say, back in the school and became a current student again? Does that sort of revest the university with the authority to revoke the degree?
No, I mean, they could discipline the student who's on their campus under the Than case and the other cases this court's decided for their current conduct, but it doesn't, I may not be understanding it, but I don't see how it makes a difference one way or the other.
Well, it seems like the case is sort of saying the authority, the scope of the authority changes once the student is no longer a current student, right? And so I'm asking you to think about whether that's really the principle being advanced or whether we're talking about what is the nature of the degree. Because it doesn't seem like, under your theory, the university should once again have revocation power if the student were to come back and enroll in a photography class or something. It'd be a current student, but that, under your theory,
But I agree.
how would that affect the scenario?
To me, it wouldn't, because they're not having action taken against them for what they're doing as a current student in their photography class. They're having action taken against them as a graduate of the university, so it wouldn't make any difference at all.
Mr. Field, it seems to me there's a two issues. One is, does the university have authority to administratively revoke or nullify a degree? The other is, does the process that the universities provide satisfy due process requirements, right? And you've argued no and no, right? You think neither is true. They don't have the authority. Even if they did, what they've done here doesn't satisfy due process.
Correct.
Focusing solely on the authority issue, do they have authority? Your argument is no, because no statute grants them expressly or implied power to do that. Instead, they would have to file suit in a court of competent jurisdiction to revoke or nullify a degree if they could show fraud or contract claim or something like that, right? And so then my question is, okay, what statute expressly or impliedly authorizes the university to file that lawsuit, to judicially revoke or nullify a decree?
I'm not aware of one, but I
So
do know.
then they wouldn't have authority to do it in court either.
Well, universities file suits all the time.
Well, but your whole argument is they have no statutory express or implied authority to administratively revoke, but if that's the standard, then we have to apply that same standard to anything they do. So where is their express or implied authority to judicially revoke a degree?
Universities still have common law rights. They are an entity. They have common law rights either by contract or by tort remedies. They have common law rights. There doesn't need to be a statutory jurisdiction, any more than in Chambers, Liberty County. Those were two government entities suing one another. There was no statutory authority for the Chambers, Liberty County entity to sue the other one who gave an invalid lease for an oyster farm. So no, I disagree with your premise. That doesn't exist.
They don't require such authority statutorily.
Correct.
Can I ask on this idea of revocation, is that really the right way to think about it in a situation in which a student did something or arguably did something that meant that it was never valid in the first place, like the hypothetical about the mask and having somebody else? And I'm wondering if it might be the difference between divorce and annulment, in which an annulment we think, well, they were never actually married. Divorce, yes, they were, and we're going to stop it for some reason. We're going to revoke that. If we think about it in that way, is it really a revocation, or is it simply a way for the university to recognize that it never actually happened in the first place?
It may be in the extreme example. I think that's a fair way of looking at it. But I think most of your cases you're going to see are not extreme examples. This is not an extreme example. SO is not an extreme example. These are true fact-finding missions where there's a serious dispute about what happened. And you can imagine the other revocable offenses for Texas State. For example, sexual misconduct is a revocable degree from Texas State. Also, harassment that, quote, annoys or alarms the recipient is a non-recognition offense at Texas State. Doing something that makes another student feel threatened. These are all things that I understood what they meant when I was on campus 25, 30 years ago. I don't know what they mean anymore, and I don't think we know what they mean 20 years from now. But that's what Texas State can do with someone's degree. And you're right, it's not a golden plaque sitting on a clerk's wall. This is what entitles someone to make a living. For a chemist or a biologist, there's no license. There's no licensing authority. It's the PhD that gives them the right to make a living. We're not playing with a student who got caught with marijuana on campus or did some other, they cheated on a test. This is someone's livelihood we're talking about.
Could the school, rather than revoking the degree, would you concede that the school could investigate the matter and make a finding that academic dishonesty occurred and maybe put a notation on the transcript that's, as there's been a finding of academic dishonesty or something like that? So some procedure short of the revocation of the degree that could vindicate their interest in looking into this kind of a thing.
Again, you'd have to look at that case on its facts to see what liberty interest was impacted or if a property right was impacted. So I don't want to concede that you could never go to court on something like that, but yes, I would think you could have the right to make a notation just like you do, but you would still have prospective relief to challenge that notation on the transcript.
Why would there be that kind of authority for someone who's a former student any more than revoking the degree? I don't understand what the true distinction for jurisdictional purposes, for example, would be for those two things.
Yeah, I have to admit, after I gave my answer, I kind of regretted it immediately. Because I really don't think there is.
The difference might be that the degree belongs to the student and the transcript belongs to the university.
Right, but the transcript is part and parcel. I mean, look, the degree is, there are two interests tied up here. There's the property interest, with the U.S. Supreme Court's recognized it since the 1800s. But this court's not written on it. Y'all are going to have to decide what that looks like. What's the property interest involved and how is it protected? But there's also the liberty interest, which is reputational. And those two things go hand in hand. And so it's a good hypothetical because it's tricky. But I do think the end result is the same, that's part and parcel of a revocation at that point. If you're telling the world, which, by the way, there's a lot of argument about reputation of the university. The Attorney General cited in 1987, they can't tell the world that they've revoked a degree. It's not reputation.
It seems like in the statute, the question about whether it's a property right or not has to do with what due process needs to be afforded. But the question about whether they have the authority to do it or not seems like it needs to focus on the statute.
And I agree. And what I heard earlier was they can do whatever they see fit pursuant to this necessary and desirable. I do want the court to look at 95.21B, because 95.21B says necessary and desirable for the management and operation of the university. And that's defined in 95.21A. It's things like building buildings, setting salaries. There is a welfare of the student clause in there, but how revocation fits into that, I don't know.
Is it a traditional and time-honored role under 51.352A for universities to revoke degrees?
Under what? I'm sorry, Ron.
Texas Education Code 51.352A, state university boards shall exercise the traditional and time-honored roles for such boards as their role has evolved in the United States.
Given the lack of any case law in this state on this issue,
it says the United States.
Well, and if you look at the United States, there's about 5 decisions in the history of the United States on this issue. It's not time-honored, it's new.
Any other questions? Thank you, Mr. Field. Ms. Quadra, we'll hear from you.
Good morning, and may it please the court. I have heard a lot of conversation today and questions asking about the nature of the relationship of the parties. It's contractual. It's contractual based on the contract on the date the student enters the university. So to answer your question, Justice Huddle, about a former student coming back and re-enrolling, there's a new contract when they re-enroll. And we're talking about property and liberty interests. And I think the liberty interest is easily lost in this conversation as we've tried to define what is a degree. Yes, it's protected property. And when is it your property? The university has tried to say that there should be no distinction between a former student and a current student. It's of no moment that they've graduated. But the moment they graduate is the moment that it becomes their property. It's when their rights have vested. And that is when their ability to sanction a student changes. They don't have jurisdiction over the students in perpetuity.
Was there a rule in place at the time that these students graduated that said the university could revoke a degree for academic misconduct?
In each of these universities, yes, Your Honor, they have
So why
rules.
wouldn't that be part of the vesting of whatever property right, that it would be subject to whatever academic misconduct might have occurred at the time they were a student?
My argument and my response for that, Your Honor, is the creation of that rule to revoke a degree is in itself an ultra vires act, because you cannot create a rule that is in conflict with your express powers. Their express powers don't allow them to revoke degrees. The only statute that mentions degree related to the University of Texas says they can award a degree. And if they want to imply a degree, have an implied power, they have to have a reasonable connection to the express power. It has to be necessary to give effect to the express power. The rule, they have not argued, by the way.
The state says that particular doctrine doesn't apply to universities, because it applies to other agencies that have been created by the legislature, but not to universities. What's your response to that?
It does, Your Honor. We're talking about the basic principles of statutory construction. It applies across the board whenever we apply anything, which is we look at the express language, we look at the legislative intent. If it's clear and unambiguous, we apply it as we understand it. Statutes here, nobody has argued that there's any ambiguity in the language of 65.31. They rely on...
Excuse me,
Yes.
if we rule in your favor, aren't we going to be an outlier for other decisions?
I don't think so, Your Honor. There aren't any other cases like this one. If you look at the other cases that they cite from other jurisdictions, they largely involve students challenging due process issues, and so the question of authority comes into play there. We would be perhaps the first in the country to directly decide that this is unauthorized conduct. And I think it's very important that we define the nature of this relationship properly and consider not just the property interest, but the liberty interest. This court has talked most recently, Justice Busby, in the Villarreal opinion, about the harm, the extreme stigma that comes with just the mere accusation of misconduct. And the university has relied so heavily claiming that their reputation is more important. The integrity of their degrees is more important. And they say, we're certifying to the world. Well, as Mr. Field pointed out, under the 1987 AG opinion, they can't tell the world that they've revoked a degree. They can't do that because of FERPA. So the reality is
Does the university have the authority to withhold a student transcript, make it unavailable to future employers or inquiries?
No, Your Honor. And so they did that in this situation. They did that to my client. And that was an interference with her use of her property and her liberty interest to pursue other opportunities.
So she has a property interest in the degree and in
Pursuing,
the student transcript held by the university?
Yes, Your Honor. And so my point was, when it comes to reputational harm, the universities don't have a constitutional right protecting their reputation like our clients do. They have a right to protect their reputation, their integrity. And when you put that at issue, the university has to give way. Their claim has to give way, which, by the way, a claim of reputational harm to the university is mere speculation, in my opinion. It just sounds good, but is it really going to happen the way it will to the individual who can get fired, who can't get a job because they don't have their PhD anymore? You can't get a job as a scientist without your PhD doing what my client does. And whereas we as attorneys, we get our degrees and then we get licensed by the state bar, there's no licensing authority. So effectively, their license is their degree.
All of that seems to me to argue in favor of recognizing that your client has a due process right to protect the degree so that the university can't take it away without following due process. But the university doesn't dispute that. I mean, if I understand their briefing and argument, they agree that whatever process they use has to provide due process to your client. The real issue is, can that process begin with an administrative process within the university to make the decision? And if they make that decision and you think by doing so they violated due process, you can sue to challenge that. I don't see where the harm is to your client if they're right on the authority issue.
There's absolutely harm to our client because the university wants due process to be exactly what they say it is.
Well, so maybe they're wrong and you win on the merits later because what they say is due process isn't enough.
But why should she go through the process that's unauthorized to begin with? That's where there's harm.
Well, and so maybe it's not authorized, or maybe it is. That seems to me to be the key.
Actually,
Here, we're not trying to decide here whether your client got due process.
yeah,
Are we?
no,
I mean,
no,
we're
no,
not
nobody's
there
passed
yet.
on that decision of misconduct either. But what I will say is, historically, this court has seen cases that are very different. You've had cases that involve students who were academically dismissed for not meeting performance standards or dismissed at the time they were a student for some kind of misconduct. This is a graduate who's years into their private life, okay? And so in those previous decisions, those other cases, we talk a lot, or the courts speak a lot about judicial deference to the schools because you don't want to second guess the academics. You don't want to second guess their judgment. You give a lot of deference because of the policy of not interfering with the educational process. That interest, that policy is not implied here. Instead, what's triggered is you need to protect the policy. The policy needs to be protecting the individual citizen from a disruption of their life, of their career, and their property and liberty interests.
Does it matter that your client, at least at some point, still had some affiliation with the university in terms of co-authoring journal articles, and does that kind of muddy everything?
I'm so glad you asked that question, Your Honor, because Mr. Davis actually made a comment that they were not seeking to go after these students for any conduct that happened after graduation. But in our case, that actually was what triggered all of these claims, is when the professor invited her and asked her to be a co-author. She didn't need to be published. She was already far into her career. She'd already had other publications, but it was to help another post-grad student. So she had no incentive for that publication at all. And I will tell you that it's wrong to be going after them for stuff after they graduated. I mean, does that mean they're going to be policing their alumni, I don't know how many thousands or millions of alumni in Texas in
Are they
perpetuity?
going after her for things after graduation, or are they going after her for things pre-graduation, but based on what was learned after graduation? I thought that was the argument.
Well, so what happens, Your Honor, is the genesis of the misconduct allegation started with the publication. And when
I recognize that that was the thing that led to the alleged discovery. I'm not saying that it was
Sure.
That's an accurate claim, but it was just the cloud lifted from the perspective of the university based upon that. But they're not saying that they're punishing her for anything she did.
that's what they
After
started out
graduation.
trying to do. And then when it was objected to on the grounds that you have no power over her for anything that's happened after she's graduated, they dug deeper in and went to their dissertation that was part and used for the article. And so this shows the imbalance of power.
Is that not, though, a due process argument itself? And so I guess I have the same thought that Justice Boyd had, I think, and that is that if we conclude that the university can do it, aside from the circumstances that you're describing, which may be troubling, but the situation that we hypothesized earlier, the person says, yeah, look, it wasn't me, it was someone wearing a mask that looked like me, just clear-cut case of fraud 10 minutes after the diploma is handed out. If we conclude that in such a situation, the universities can in fact use an internal revocation process subject to judicial review, does that not answer this case? And then it's the next case in which we say, all right, now that we know that they have the right to do it in some circumstances, now we have to decide whether those circumstances are as broad as universities think, what process is due, whether all the things that Justice Bland mentioned earlier, that deprivation to either you or your colleague would mean that the thing was void. That seems like the next case, not this one. Am I wrong about that?
I'm not sure I follow all of your question, Your Honor, but bottom line is they're not authorized to do what they're trying to do. We need to go back to the statutes.
Let me be clear then. The question I'm saying is if we decide that they're ever authorized, I know you think that they're not, even in my crazy hypothetical, your position is that they are not authorized to revoke it, they would have to go to court or something, correct?
Indeed.
If we disagree with you and say that even in that crazy hypothetical, or at least in that crazy hypothetical, an internal process is sufficient and it's authorized by statute, then that's enough to resolve this case, I think, because this case is only asking about whether there is or is not ever authority to revoke a degree.
I sort of lost track. I'm sorry to say what the crazy hypothetical was.
Okay, the hypothetical is they pull off the mask. It's actually the scientist from Harvard and not the person who got the PhD.
Sure.
And so the person who got the PhD goes out onto the steps with the diploma in hand and says, "Ha ha, joke's on you. I hired the brilliant scientist who had a Mission Impossible mask."
Yeah.
Okay, so clearly that person did not qualify the degree. You're with me on that, right?
Sure.
And the question is, if this court says in that circumstance, the pulling off the mask circumstance, the university has the administrative authority to revoke the degree, subject to judicial review. If we say that that exists, does that end this case?
No, and here's why, Your Honor.
Okay.
You're assuming that there is judicial review in the rules. The university rules do not allow for judicial review. And that brings me to a point, and I'm over my time, but if I can quickly respond, because this is important. Mr. Davis mentioned that they had agreed to an abatement period for SO, where if they decided internally to revoke the degree, they would allow her time to go to court. That highlights the very problem of the process. It's been an ad hoc process. They decided that in the middle of a trial court hearing, saying, Your Honor, if we have this disciplinary hearing and we revoke her degree, which is not guaranteed, but if we do, we'll give her 30 days to go to court. That's not in their university rules. You've got to have some structure. There are rules for a reason. They don't get to change them as they go. And under University of Texas versus Babb, that case clearly states the nature of the relationship is contractual, and the rules that apply are the rules on the day the student enrolled and entered that university. They can't change them as they go. They're going to come back and say, by the way, that the answer to no due process is to give you due process. But that's not where this case needs to be decided. It needs to be decided on authority. It needs to be decided that they don't have the authority to do it internally. You decide how they do it, which is in a court, because you properly ascertained and stated, go to court and sue for your property under contract rights or any other claim that can come. There's no limitations on them.
I think you answered my hypothetical by fighting the hypothetical. I just want to make one last effort. If I say that there is authority in the crazy hypothetical, what basis is there to say that that's the law now, right? In this world, there is authority for the university to do that revocation. I know you think that's a terrible rule, but hypothetically, that's the rule. How can we say that there isn't authority in your situation? Is there a way to do that?
Authority and one and nothing. There's no authority in our situation. It's got to be by statute.
But that's because you think there's no authority even in the other situation.
Yeah, I don't think it's there
All right,
either.
I think you've answered my question. Thank you so much.
Thank you, counsel. You judge, Your Honor.
Any other questions? Thank you, Ms. Kawaja. Davis, you have 5 minutes.
Thank you, Mr. Chief Justice. Going to your point, Justice Young, and your point, Justice Boyd, there's no due process claim at issue here. There are 3 issues: degree revocation authority, ripeness in one case, retrospective relief in the other.
So for how long have the universities asserted this authority? Going back into the past, what's the origin of these policies?
I haven't traced it back beyond knowing that it was in existence at the relevant time, and we see that in the rules that are in the record.
How is it not a due process?
Sorry, go ahead.
Go ahead.
If you're relying in part on the notion that this is a time-honored authority that universities have traditionally exercised, I would think we would need to know the history of these universities' assertion of this authority.
Well, let me point to this then. In 1987 is when the legislature passed Section 51.352A of, it's the current version of the broad power given to universities. And the legislature there said that we want university boards to evolve, to do the functions as boards' roles have evolved in the United States. And just the year before, we saw the Ohio Supreme Court deciding in Waliga that universities do have this implied authority to revoke degrees. Now, I'm not saying necessarily that those were connected, but I think that does go in part to your historical question. And that's as far as I've traced it for these purposes.
Well, we know that the rules were not in place when AG opinion 446 was issued in 1969.
That's right, and that was one of,
The AG said, I can't find any statute or rules that give authority. So sometime after 69, the universities enacted rules to let themselves do this.
yeah, so the AG opinion said two things. It was one, that there was no rule that they could find that allowed this, and two, they couldn't find any other court anywhere in the country that had read this express authority in. But then, of course, starting in 1986 with Liga, we do have a bunch of other decisions from around the country that do find that authority. That's the question here,
And so, I mean, I feel like we need to go back further than 1986 to know whether this is historically, traditionally part of the role, assumed to be a power that is within the hands of the board of a university over its former students.
Well, then I would point the court to the dissenting opinions in the Court of Appeals that went back more than 200 years to the King's Bench, I believe it was, in a case in which there was authority to revoke a former student's degree. And as the dissenting justice explained, Texas is among the states that have incorporated the common law. So I think that is in our tradition.
So let me ask you, so if in fact we were to find that in this hypothetical that Justice Young has come up with, that somebody was pretending to be someone else and somehow was able to pull that off, and let's say if we say that that's one situation and that's all we're dealing with here, where the university can revoke the degree. So where would the line, because there's got to be some process even for that. You can't just say, well, they were wearing a mask. There has to be some kind of evidence there to prove that in the university said. There's got to be some process. And so where would you say the line would be, and what would that be? What would that look like?
Well, I'm not sure what line Your Honor is talking about, but I would agree that there has to be process. So in Justice Young's example, the student gets the diploma and walks over to the microphone and says, ha ha, everybody, I completely cheated on everything, but now I have the degree, you can't do anything to me. Well, the university would have to investigate that and have to run it through its process. And if there were a due process complaint, that could be brought to the courts. And that's no different from what we have here, again, because we're talking about whenever the misconduct was discovered, the misconduct happened while the students were enrolled, and that's the key distinction. And just one point, my friends on the other side, under their view of express statutory authority, Texas A&M would have no authority to award degrees. And that's true of several other universities. That's a point from the dissenting opinion as well. The context here is key. This court says that all the time in statutory construction. You don't look at words in isolation. You have to look at the context. Here the context is the education code, where the legislature knows and legislates against the backdrop of this court's decision saying you don't have to spell everything out when it comes to universities. I see my time has expired.
Any other questions?
Can I ask just one last one, Chief? The prospective, retrospective distinction in KE, I find kind of confusing, your point, and it seems to me that you are calling retrospective something that really is just future looking, whether or not this person can say, yes, I have the degree. And the thought there is that if, in fact, it was wrong for the university to say, we're taking your degree away, that's all future looking. We're asking the state to adhere to what the law actually is in an ongoing way to avoid destroying somebody's life. And you're just saying, well, too bad it's happened. That's the way it goes. I don't understand how that could be.
As both this court and the U.S. Supreme Court have noted, the line between retrospective and prospective is notoriously difficult to draw. That's why I focused on the degree revocation authority as a way to dispose of both of these cases. But to answer your question, I would say no matter how the relief is characterized, it would have the effect of undoing that previous administrative decision. And in that respect, it is retrospective.
Any other questions? Thank you, Thank you, counsel. The case is submitted, and the court will take a brief recess.
All rise.